Professor Deborah Healey from UNSW in Sydney, Australia, and I'm here to talk about competitive neutrality and government policy in the context of the OECD Global Forum on Competition 2021. The basic proposition with competitive neutrality, of course, is that a level playing field offers efficient supply of goods and services to consumers at the best prices and fosters innovation. And in this context, the interventions of government in the market can have a substantial impact. There is a significant impact where government businesses are in competition with the private sector. And of course, they shouldn't have a competitive advantage just because they're owned and controlled by government. So competitive neutrality is really the steps or mechanisms we put in place to ensure that the market is neutral or that a level playing field exists. And it's interesting because competitive neutrality has both national and international implications, but we won't have time to talk about those. And there's also a very interesting relationship between competitive neutrality and industrial policy and state capitalism. And of course, that will differ as between jurisdictions and will differ as between the approaches that a jurisdiction takes to industrial policy and state capitalism. In terms of formal developments about competitive neutrality, the OECD Council recommendation on competitive neutrality in May 2021 is an important step forward, I think, to global implementation and global recognition of the importance of competitive neutrality. And competitive neutrality in that broad sense requires multiple initiatives, and these are included in the recommendations. And some of the initiatives that they mention are the application of competition law to government business, and of course, its enforcement in that system is also very important. There's no point having application of competition law to government businesses in your law if it's not enforced. The recommendations also include routine competition impact assessment of policies, laws and regulations. They include the fact that government businesses, SOEs and other entities might need to have adjustments made for the advantages that they have because they're owned and controlled by government. And finally, the recommendations talk about fair, open and discriminatory government procurement and a clear policy for transparent public service obligations. And of course, all of those things are important. So when you look at the way that different jurisdictions implement competitive neutrality, they're all different. The approach of the EU, for example, is to include some provisions in relation to competitive neutrality in the Treaty for the European Union. In China, in the anti-monopoly law, we already have provisions which deal with administrative monopoly, which is an ex post facto system prohibiting anti-competitive rules and regulations, and they are enforced under the anti-monopoly law. They're also proposing to implement their system of fair competition review, which already exists, into the law as well. So they'll have an ex post and an ex ante system in that law for dealing with anti-competitive laws and regulations. In the Philippines, they have a very well-developed competition policy, and that's included, parts are included in their Competition Act. And in Australia, the competitive neutrality initiatives are not included in the law, but they're included in our national competition policy, which is an agreement between our Commonwealth government and our state and territories government. And that's been going for more than 25 years. And in that context, our competition regulator, the Australian Competition and Consumer Commission, does not have a role except for advocacy. So the recommendations also look at issues around achieving public policy objectives which might need to override competition concerns in certain circumstances. And that's really what I want to focus on in this presentation. In the recommendations, it says that achieving public policy objectives will in certain circumstances require exceptions to competitive neutrality. And they define public policy objectives as objectives befitting the public interest in the jurisdiction. So you'll see that that is fairly subjective in its application. And of course, the way that that is viewed or interpreted will depend on things like the stage of development of the jurisdiction and other considerations impacting its political economy and just the view of its government. Now, what I would say about this, while I understand why it's there and I think it's an important concession, to ensure the benefits of competition are fully achieved, exceptions should be circumscribed and carefully considered. And this raises important issues of the philosophical balance between the sovereignty of the individual government and the policies that they want to deliver to benefit the public, and the weighting in turn that they give to competition in any particular case. And there's really some disconnect between the two in some situations. And important questions arising from that consideration are these, which are on this slide. Where should the line be drawn between governance and the public policy role of government and its role as a market participant? What if it, for example, is selling off a government business? How carefully do governments in reality consider the impact of their policy decisions on market competition? That's really important. You know, you need to see them doing it in practice as well as having it written on the books. And then you need to look at things like, is unfettered competition always necessary or appropriate to achieve the greatest public good? And I would say that probably it isn't. But where it's not to apply, where competition is not to apply, needs to be very carefully considered. And then ultimately the last question is, can governments be accountable for their failure to consider the long-term impact of their deals on competition, except at the ballot box? And I think they're considerations that we all need to think about. So I'd just like to talk about a few examples of government policy making in Australia, which have raised some eyebrows despite Australia's very well developed and successfully implemented competition policy. In Australia, we have, as I say, a well-developed policy, but in the application of competitive neutrality, the overriding public benefit is always considered, and in most cases, the overriding public benefit is to have a competitive market. But we do have examples where profit maximisation by individual governments appears to have been considered at the expense of the long-term competitive impact of a deal, such as the privatisation of government assets in certain circumstances. We have, for example, had the sale of a major airport where the agreement terms gave the purchaser the first right of refusal on building the second airport, and also gave that purchaser long-term monopoly rights over car parking at the major airport. So it's not to be retendered ever. While they have the airport, they will have the car parking. No competition. We've also had examples of long-term leases of critical infrastructure, such as ports, with restrictive conditions about building additional ports nearby, or keeping container throughputs to a particular level, with the government being penalised if container throughputs through their competitors went up above a certain level. We've had sale of our government land titles registry with an immediate escalation in user costs as soon as the sale was completed, which was the subject of some discussion. And we've most recently having the sale of the government's 49% share of the toll road to the owner of the other majority shares, the owner of the 51%, but where that organisation or that firm was already dominant in the city's toll road network. So things like that have led the competition regulator, the ACCC, to comment on some of those deals. And the comments have been around the idea that while the benefits of privatisation and these other deals to the community are recognised, the comments made that many of our key economic assets have been privatised without regulation in recent years, and often with rules designed to prevent them ever facing competition. So the ACCC has advocated regularly against policy decisions which entrench market power without some regulation or prevent the incumbent from facing competition after the transaction. And it has argued that governments should privatise for efficiency or not at all. So we have what appears to be a gap in our policy. And the ACCC has no formal advocacy role in relation to issues like this or other issues, but it can be requested by government to review and report on issues. It does, however, routinely advocate for competitive outcomes in a whole range of situations. So one of the options might be to give the ACCC a formal power under the Competition and Consumer Act to investigate and advise government on issues of this kind prior to their implementation. So that would be governments at all levels, to advise governments at all levels. What about the imposition of obligations on the Commonwealth itself and the state governments? They're the people who are doing the privatisations and entering the long-term deals. Some of the ways that this might be dealt with might be to have a public review of privatisation proposals by some government or state body, Commonwealth or state body, and we do have those already. We have them looking at competitive neutrality complaints in relation to government SOEs at Commonwealth and state levels. Perhaps they could look at privatisation proposals as well. Alternatively, we have our national competition policy under an agreement called the Competition Principles Agreement. Perhaps we could try to have all governments agree to disclose and justify in a transparent way why competitive outcomes have been compromised in the name of public benefit. And in a number of cases, that might be a very legitimate thing to do, to actually have public benefit overriding competitive outcomes. But it would be good to know why these decisions have been made, rather than just being told it's for the common good. This could also be done by laying some sort of analysis or a report before Parliament, their own Parliament, for scrutiny. We could mandate full disclosures of analysis in relation to these issues in the annual reports of the body selling the asset. Or ultimately, we could impose regulation on assets with significant levels of market power to prevent monopoly conduct. And we do have some regulation in relation to telecommunications, gas, electricity, but not generally. And perhaps we could broaden the scope of that regulation. So I thought that it might be interesting to discuss these issues, and it may be happening in other countries, but it definitely appears to be a gap in Australian consideration of competitive neutrality, and it may well have severe lasting consequences, as has been said, where we don't end up with a competitive environment. It really sets up a tax on future generations who will have to use those facilities. So thank you for listening, and goodbye.